Hello, everyone. Welcome to Transportation Law Lecture 2 on Common Carrier versus Private Carrier. Here are the rules in determining a common carrier under Article 1732 of the Civil Code. 1. It makes no distinction between one whose principal business activity is the carrying of persons or goods or both, and one who does such carrying only as an ancillary activity. 2. It makes no distinction between a person or enterprise offering transportation service on a regular or scheduled basis and one offering such service on an occasional, episodic, or unscheduled basis. 3. It makes no distinction between a carrier offering its service to the general community or population and one who offers services or solicits business only from a narrow segment of the general population. Fourth, a person or entity is a common carrier and has the obligations of the common carrier under the Civil Code, even if he did not secure a certificate of public convenience. Fifth, it makes no distinction as to the means of transporting as long as it is by land, water, or air. Sixth, it does not provide that the transportation should be by motor vehicle. 7. A person or entity may be a common carrier even if he has no fixed and publicly known route, maintains no terminals, and issues no tickets. 8. A person or entity need not be engaged in the business of public transportation for the provisions of the Civil Code on common carriers to apply to them. Ninth, the carrier can also be a common carrier even if the operator does not own the vehicle or vessel that he or she operates or has to actually hire one. 10th, the carrier can also be a common carrier even if the operator subcontracts the carriage of goods to another entity. In one case involving a school bus service operator, the Supreme Court held that despite catering to a limited clientele, the petitioners operated as a common carrier because they held themselves out as a ready transportation indiscriminately to the students of a particular school living within or near where they operated a service and for a fee. In another case involving customs brokers, the Supreme Court regarded them as common carriers because transportation of goods is an integral part of their business. In another case involving lighterage through barges, the Supreme Court considered it as a common carrier whether its business of carrying of goods is done on an irregular basis rather than scheduled manner and with a limited clientele. A common carrier need not have a fixed publicly known route, nor does it have to maintain terminals or issue tickets. In one case involving a freight forwarder, the Supreme Court held that the liability is limited to damages arising from its own negligence, including negligence in choosing the carrier. However, where the forwarder contracts to deliver goods to their destination instead of merely arranging for their transportation, it becomes liable as a common carrier for loss or damage to goods. In another case involving Transportation Network Company, the Supreme Court held that when they put themselves online, their services are bound for indiscriminate public consumption. Hence, they are considered a common carrier. As to a charter party, the Supreme Court held that a charter party may transform a common carrier into a private carrier. However, it must be a bareboat or demise charter, where the charterer mans the vessel with his own people and becomes, in effect, the owner of the voyage. Now let's summarize the distinctions of a common carrier and a private carrier. As to definition, a common carrier is a person, corporation, firm, or association engaged in the business of carrying or transporting passengers or goods or both by land, water, or air for compensation, offering such services to the public, whereas a private carrier is one who, without making the activity a vocation, or without holding himself or itself out to the public as ready to act for all who may desire his or its services, undertakes by special agreement in a particular instance only to transport goods or persons from one place to another either gratuitously or for hire. As to the governing law, the provisions on common carriers of the Civil Code, the Public Service Act, and other special laws relating to transportation govern the contract of common carriage, whereas the provisions on ordinary contracts of the Civil Code govern the contract of private carriage. As to the diligence required, a common carrier is required to observe extraordinary diligence and is presumed to be at fault or to have acted negligently in case of the loss of the effects of passenger or the death or injuries to passengers, whereas the diligence required to private carrier is only ordinary, that is, the diligence of a good father of the family. That's it for today's lecture. Thank you so much for listening.